Yes, Mr. Dobbins, just before you go on, I have got a meeting shortly after 4:15, so we will rise promptly at 4:15.
My Lords, I was going to go straight to the judgment then.
Yes, that would be very helpful.
Particularly to pick it up at paragraph 155. You have the judgment in your core bundle.
We do. Yes.
So, my Lord, we say correctly, the judge concluded at paragraph 155 the fact that a benefit is disproportionately claimed by a particular group can't be enough. There can't be a foundation upon which to make out indirect discrimination. And in our submission, that must be right. So, my Lord, and we see in the paragraph beforehand that he is setting out the test for indirect discrimination. But then at paragraph 156, instead of going straight to the question of whether or not there was disproportionate disadvantage arising from the neutral measure, the analysis switched to the comparison with the housing element and switched to an analysis that doesn't apply under indirect discrimination at all, whether or not making an exception for one group of claimants but not another was discriminatory.
Why do you say that doesn't arise under indirect discrimination?
Well, my Lord, here the neutral measure is the childcare element. So the test is clear who, in terms of who's entitled to that, is disproportionately disadvantaged by the way it operates. Housing is a different benefit, albeit incorporated within universal credit, which is paid on a liability basis. So you're not comparing the people that are subject to the neutral measure. You're in fact comparing here, for example,
could you perhaps say that the neutral measure was universal credit for entitlement to universal credit, and that includes these two sub-elements, which are effectively intended to reimburse you for actual costs. So you've got two groups of people in an analogous position within the universal envelope, within the overall envelope of universal credit. One that is predominantly, almost exclusively female is treated one way, and one that is, so far as the evidence shows, 50-50, is treated another way. But assume the two situations are analogous. You may of course say they're not, but wouldn't that be indirect discrimination?
No, my Lord, I don't accept that it is, because you're comparing two groups of people who are subject to a different rules. My submission, that would come under the rubric of direct discrimination.
Yeah, but it's the fact they're subject to a different rule that is the subject of complaint.
My Lord,
they're in the same position, and yet they're being treated differently.
So, my Lord, our submission is that the neutral measure is the childcare element, and what you
I know, but that's your submission, but it's not self-evidently a correct submission.
And that direct discrimination, in the context or the analysis that the judge applied, that's direct discrimination because you're taking two different groups of people who are subject. So in his analysis, he compares it to having two officers, one with the mixed group of people, one with women, and saying, well, if you take those two different groups and one's applied, and the disadvantaged terms are applied to the women, that makes out indirect discrimination. In my submission, that's direct discrimination.
Why is that what's the authority for saying that situation would be direct discrimination?
Oh, my Lord, that follows on the basis that there are two different measures in question, housing and the childcare benefit. So in those circumstances, you're looking at two measures, albeit that they fall within universal credit. And I think there are further submissions that must follow on from that as well, my lord, if you were to follow that line of reasoning. That wouldn't any longer be prejudice or discrimination on the basis of gender, because women do get the advantageous terms as regards housing. So here, and in fact, the women would fall within both groups, which is the position.
Yes, but the point is they're disproportionately represented in both groups. They're all, one group, which is less well treated than the other, is almost exclusively women. The other group, which is more advantageously treated, is, let us say, 50-50.
Yes.
Well, that's a classic, isn't that a classic indirect discrimination? Situation?
In my submission, that wouldn't follow, because obviously women are also the beneficiaries of the measure when it comes to housing. So in this case, for example, the claimant was also the beneficiary of that in relation to housing. And that's why in my submission, that sort of analysis based on indirect discrimination doesn't follow.
Well, you can see it if you're just stripping out those two elements of universal credit and comparing one against the other. But you're right. But my Lord's question was slightly more focused, which is if you have a general benefit, universal credit, which is applied across the board, men and women alike. So that's a neutral measure. It has various elements to it. And the same rules apply across the board as to who qualifies for those different elements. But as regards one of those elements, there is a disproportionately disadvantageous effect on the women who claim than the men who claim. Now, I can't see at the moment why, in theory, that can't be a proper comparator, although actually you get to the same place by simply directly comparing the men and the women who are claiming the childcare.
I think my submission is that it's more complex
within
the groups that you're trying to compare when you have women in the group of people who are the beneficiaries of what is said to be, although that's going to be my second point, a more advantageous position as compared to the less advantageous position. And in my submission, the status then that you're comparing is people, it's then based on the rules, because there are also men within the group of people entitled to the childcare element. That's a status or a distinction based on a rule as opposed to gender. But there's a more fundamental point and difficulty with that. That assumes that being paid housing on the basis of a liability, in fact, practically actually makes a difference to those two groups of people. And it's our secondary submission about that of course doesn't follow, because the fact it's paid on a liability doesn't change the fundamental point that it is still paid in arrears. So we say on that basis, that of itself can't be.
But that's a different point. It's a different point. At the moment, we're just on the question of whether you've got two groups being differently treated.
Yes.
With a and why that can't be prima facie indirect discrimination, where there's a gender disproportion between the two groups.
Yes.
If we were in an employment law context, we'd say it was Enderby type discrimination. Maybe it's unwise to repeat other contexts.
But my lord, that second point is fundamental here as well, because basing the comparison on a disadvantage that may not actually come to pass or be realistic is obviously important. And as we'll see when we go through the judgment, the judge appeared to accept that as well.
Yes, I am.
So, my lord, then going to the second part of his analysis on this, paragraph 157, we say that that was right, that what was being attacked was the childcare element, and that what one had to do was to look at the people who were entitled to that. And that when we come to that part of his analysis, there wasn't any basis upon which, or any proper evidential foundation upon which to say that women were in fact more disadvantaged by this measure, and that that was an analysis that rested entirely upon the resources available as between men and, well, single men and women, single women and men in the whole of society. So there wasn't any comparative data to give that argument the foundation in terms of the proportion of women who could make a payment as compared to men. We say in that regard it's obviously important that everybody who's entitled to universal credit has an income below a certain level. We say that the judge was wrong when he said at 159b that within the group of people who are eligible for CCE, the proof of payment rule is bound to have a greater adverse effect on women than men because women earn substantially less. It's our submission that that was to trespass into a line of reasoning which isn't permissible under indirect discrimination. And we'll come to Williams, the case that says you can't use impecuniosity as a status or a basis for indirect discrimination. And what we'd say also, obviously, about that is that there may be any number of factors which bear upon whether or not someone is able to make an upfront payment that doesn't have anything to do with gender. And the three examples, or the three witnesses who give evidence in these proceedings on behalf of the respondent, demonstrate that. So the witness who we looked at, whose universal credit statements we looked at first, sets out that she had savings and took out an advance to pay for her initial payment of childcare, and the witness SC had a payment from the Flexible Support Fund, which she didn't have to pay back, which paid all of her costs for the first month. So in our respectful submission, that points to the variety of factors which may be applicable as regards whether or not an individual is able to meet an initial payment of childcare that are completely unrelated to the other resources that they might have available to them. But we say that the argument goes further than that again. This is not just about an upfront payment. In those cases where the upfront payment was made, it was repaid in the universal, in the next payment under universal credit. And we see, for example, in that witness's statements that I took you to, that the childcare amount is continuously reimbursed after that point.
Well, what it amounts to, doesn't it, I suppose, is a failure to be able to get off the ground, or potentially a failure to be able to get off the ground in the first month's childcare. So if somebody is earning a very low wage and can't spare the resources to be able to pay the first month's worth of childcare, they never get onto the wagon. But the point you're making is that once they're on the wagon, then it keeps rolling.
It should do, yes. So if you get into a regular cycle, and we see that in the witnesses, in the statements of the witness, I'm just being sensitive to her by not mentioning her by name,
yes.
But we see in respect of her statements that that's precisely what happened. That every month she was being recompensed £646.
So it's ultimately a cash flow problem.
Yes. So for some people, and that's why I took you to her example, her payments went down in summer. We obviously recognise that for some people their payment might go up in the summer, but they'll get that money back again.
And you
when
say
they're
that in any way
recompensated.
there is an inbuilt safeguard within the scheme to cover that eventuality, because you can either ask for some of the money up front in advance, as we've seen, the £70 or £80 or whatever it was that was on the figures that you showed us on the
Yes.
actuals, or you can apply to what I keep calling the hardship fund, but it isn't, which is the discretionary payment, but you don't have to pay it back.
And that's why the witness statement of the witness SC, who's anonymous, is a good example of that. She's someone who got all of her payment, who got everything paid for up front through that fund, and you don't have to pay that back. Now, we don't rely on the existence of that fund in order to demonstrate that this rule is manifestly without reasonable foundation. But obviously on the evidence before you, there are only 3 women, and one of them had recourse to that fund to pay her costs. And the other reason why just comparing or basing this argument on resources doesn't really work either is because if you are a lower paid person under universal credit, you will then, the amount of universal credit that you get will be higher. So again, we saw that in the statements that I took you to. So even if you were to take within universal credit men and women and said men are higher paid, well, built into that is that women then may get, dependent on where the limits lie, they will get additional universal credit. And to take the claimant, the respondent in this case as an example, as I said at the outset, she reduced her hours, so she was lower paid, but her universal credit payment went up in order to meet that, in order to give her a bit of extra cushion, as it were, when her earnings fell. So there are all sorts of quite complex reasons why just basing this on resources isn't straightforward and doesn't easily fit within the rubric of discrimination. And that's before we get to the other point that I was making. And to be clear, I wasn't suggesting that the comparator in this case was people who get universal credit compared to everyone else. I was simply relying on the more general point that being paid in arrears, and for some people having to pay your childcare costs up front, is a reality. And again, we fall back on the fact that universal credit is supposed to replicate the way that most of the working population is paid. My lord, the judge went on in this case to say that the proof of payment rule was like a height requirement. And for all of the same reasons, we say that that analysis doesn't work either. A height rule is just fixed. If you're 5'4" like me, you're never going to make it to 6 foot. There's nothing that you can do about it. But again, we'd say that that sort of analysis just doesn't apply again in respect of a proof of payment rule, because it will depend on a number of factors that depend on the same sorts of things. Have you had recourse to the flexible support fund? How expensive is your childcare? Do you have other help? If you're a single parent, does the other parent help you out? Do you have some savings to help you make that initial leap into work? So, my lords, we say that for all of those reasons, the judge's analysis, when it came to discrimination, was wrong as a matter of law, and that this system just doesn't come within the concept of indirect discrimination. My lords, and my lady, that's all on the basis, or that's without going to the judge's approach to the evidence in this case. But the second part of our challenge on this ground is that his approach to the evidence was also wrong, because every indirect discrimination case is brought on the basis that there's an incontrovertible basis for saying that more men than women are prejudiced by the measure, or in the DH case, that Roma children were disproportionately segregated into special education. You saw that in Detrizio and Hugendic. And my lord, you see that, and I'm not going to take you to these, but JS tab 13, paragraphs 261 and 181, there was a statistical basis for pointing to the disproportionate disadvantage. DA tab 20, paragraph 22, as to the effect of the revised benefit on cap on families with children. The C case in the Court of Appeal, tab 21, 718, 126. That links to the principle that was already set out in Delve, which is also set out in SG at paragraph 15, and the Takire case, tab 14 at paragraph 89, that the court's concerned with judging the system and whether or not the system is indirectly discriminatory rather than personal circumstances. And we say that in this case, the High Court wasn't in a position to make findings about how the proof of payment rule affected those entitled to the childcare element and the extent to which the rule disproportionately disadvantaged women as opposed to men. And we say that the court's inquiry should have stopped there. On the higher, broader level, there wasn't any evidence at all about the statistical breakdown of those entitled to childcare, save for the broad statistics that the High Court pointed to about women's earnings. We say there was no evidential basis upon which it could be said that as regards men and women entitled to the childcare element, that women were in fact more prejudiced than men by the requirement. And then taking it to the granular level in terms of the evidence advanced by the respondent, we say that if you look at that evidence, that the causation required and set out clearly in cases like Delve couldn't be made out either. My lord, the respondent in this case is claiming damages, and what the High Court appeared to suggest was that it was enough that a system contributed to her difficulties, and the extent to which it was the proof of payment rule as opposed to anything else could be investigated in a damages claim. We pick that up at paragraph 149 of the judgment. The judge said that he had no doubt there were other causes of the difficulties, and it might be necessary to identify which of these causes predominated if she were to pursue a claim for damages. It's our submission that that approach was wrong in law and contrary to all indirect discrimination cases. And the court criticised the approach on behalf of the Secretary of State.
Sorry, hang on, I haven't quite said. What's wrong in law and contrary to all indirect discrimination?
That any sort of the analysis should rest on individual circumstances in the way that the analysis proceeded in this
Well, no, that can't be right, can it? You will often get a case in which someone is a victim of indirect discrimination. They have to show that the measure is indirectly discriminatory, stage 1. Then they will have to show it impacted on them,
yes,
stage 2. And then you'll have to show what you lost, stage 3. At stage 2 and at stage 3, it's all about your individual circumstances,
well,
but not at stage 1.
That has to be reconciled with the principle that the court is concerned in Article 14 cases with the system.
Yeah, no, but I have reconciled it.
Individual.
I have. It's reconciled by that being the test at stage 1. You haven't shown us any case law that says that if there is an indirectly discriminatory system, and it impacts on an individual, that in deciding whether it impacts on an individual and what compensation that individual should have for the impact on them, yes, you don't look at their individual circumstances. How could you not?
I think the point in it may be that I'm at cross purposes with you. The point is that in indirect discrimination cases, in all of the ones that we've looked at, there is always a robust statistical basis for being able to understand
I absolutely understand.
that the disproportionate impact is on women.
Oh, yes. That was an earlier point you were making earlier, and we've got that. But I thought you were moving on to a different point based on what the judge said between the hole punches in page 149 about having to work out in the context of a damages claim
Yes.
the extent of the causative impact of the indirect discrimination on her financial position. And you were saying that was wrong in principle.
Well, it's wrong in principle to rely on personal circumstances, I submit, in order to demonstrate the indirect foundation absent the disproportionality not having already
Okay, so this
been
isn't a separate point at all.
So that's what I'm saying is you can't use individual circumstances in order to demonstrate causation.
I'm lost. Let's in a public law claim where you're simply concerned with the declaration as to the effect of a measure,
Yes.
the effect on any individual is only relevant to the extent that it is evidence of the indirect impact of the system,
Yes.
and one individual will never be enough statistically.
Yes.
Got that. And if that's your only point, fine. But I thought you were making a different and further point.
I am.
But I don't understand what that point is.
Well, I'm going to come to it, and if you think that it isn't relevant,
Well, it's not so much I didn't realise, I just don't understand it.
then you can tell me. The point was that when you looked at a granular level or at a forensic level at the respondent's finances, or if you looked at her universal credit claim, then it became very difficult to understand why it was that the proof of payment rule constituted the disadvantage,
Yes.
as opposed to all of the other things that appeared to be going on financially at the time as well. So to take the example of the respondent, we know from her evidence that she gave up work the month before she started her new employment. So she already started, as it were, at a disadvantage because she had a month off before she started work and was therefore reliant on a universal credit payment. Do you want me to take you through the forensic?
No, I want to understand the point at the moment. And I'm just reminding myself, the reason why is what the judge's declaration
Yes.
was. He didn't make any claim about damages. He made a claim.
No, he didn't. The damage is part of this case has been stayed.
The declaration he made was that the application to the claimant of the regulation was incompatible with her rights
Yes.
under Article 14. So it is a claim. It is to that extent a declaration about the impact on her.
Although, in fact, the judgment is put in broader terms.
Yes.
Which is why one of the grounds of appeal is, although it's not really a ground of appeal, it's more that the judgment shouldn't have been put in general terms if, in fact, this was all just personal to the claimant in this case.
But I don't think he has. I don't think, I certainly, with respect, don't read this judgment as turning on the particular individual circumstances of the claimant.
Well, at paragraph 149, what he's saying about causation is that he doesn't think that there's any need to get into a forensic examination of what caused the indirect discrimination. He's saying that it's enough that the proof of payment rule might have contributed to it, and that any further findings about that would have to...
Well, isn't that just a general point about the law of causation?
Yeah.
You don't have to show generally as about in the law of causation that the measure or act complained of was the sole cause of your loss. You just have to show that it was a cause.
Well,
And that's what he actually says, isn't it, in paragraph 149?
it's my submission that Delve demonstrates that when it comes to Article 14, you have to be able to demonstrate a causative link you have to be able to demonstrate that it is the measure that you are complaining of, which is the source of the disadvantage which you say you're suffering. And in a
Well,
context
it is the source
where
of the
it
group
is-
disadvantage.
Yes.
Yeah.
You're right. The declaration is framed by reference to her, but I think that's largely for procedural reasons.
Yes.
What this actually is a declaration about the effect, about the group effect of regulation, whatever it is, on women.
Yeah.
And the Delve point obviously is right that a measure won't, for a measure to have a disproportionate impact on women, it must be part of the cause of that impact. Otherwise, it wouldn't have a disproportionate impact on women.
Yes.
But there's no, the question of whether it had a disproportionate impact or whether it had a not so much disproportionate impact, it had a prejudicial impact, a detriment if we use employment law, but on this particular individual, who may not be typical of her group generally, is neither here nor there at this stage of the judge's reasoning. It'll only become relevant, as he himself says, if she pursues an individual claim for damages.
So then maybe it comes down to this, my lord. On what basis does the judge make a finding about the differential effect on women as compared to men? That's the first point.
Yes.
My point is he couldn't make that finding by reference to individual circumstances about this particular claimant.
No, he couldn't,
That-
but he didn't.
That is the
You're
key.
pushing an open door,
Yeah.
I think. We all agree
I
he
think
couldn't.
I was just reading his. You might say that he's put the cart before the horse in a sense, because he deals first of all with your point about causation and says it doesn't work for the reasons that he gives in 149, and then he goes on to the overall impact of the proof of payment rule, not by reference to individual circumstances, but by reference to more general evidence, and that in one sense is a reversal of the proper order of things.
Yes.
But for my part, I don't see the first point leaching into the second.
Well then, my lord, that assumes then that the evidence about personal impact in this case was irrelevant.
Well, I think that's right. Personally, it's
the-
illustrative, and it's always an individual who brings a case. Claimant can't resist putting in evidence about their individual circumstances, so the judge has a human context for it.
Yeah.
But it can't be a circumstance of any one individual can't be probative of anything if you're making a general attack on the impact.
Well, then I think we're in agreement about that. And obviously the concern here is when you're basing prejudice on resources and some people having more resources than others, then obviously the concern here is that you do, if you're looking at the individual case, then you do have to get into the minutiae of what in fact was making life difficult at that time, or what
I'm not
meant
sure you do. If you were able to prove, say by statistics, you say there aren't any statistics here, but in principle, if you're able to prove by statistics, or indeed by common sense, courts are allowed to know what the way of the world is, so they have to be jolly careful, because sometimes their experience isn't wide enough to tell them. But certainly, Lady Hale has said in employment context, you don't always have to have statistics. Sometimes it is just obvious, and sufficiently obvious in a particular case, not to have to
yes.
have to worry. You have to be cautious about that, of course.
Yes. So, Milo, can I just say about that then? There isn't this sort of robust statistical basis in this case about the effect that the way that childcare is paid for has effect on women. That
I'm
was
beginning to wonder where you begin to get that statistical evidence. How do you even go about trying to gather it?
Well, my lady, that's obviously in the
You
context
couldn't, could you? I mean,
of for example, there is the stakeholder evidence in this, the evidence from the charities and the campaigning group, and that doesn't, the sorts of charities that are often informed or able to conduct research, and there isn't any of that sort of research.
well, what you
So-
don't have is a statement by one of the charities saying, in the past year or so since Universal Credit has been operating, in this particular way, we found that 75% of our constituents have come to us complaining that they can't afford to pay an upfront payment and therefore they can't claim this element of universal credit.
I would go further than that. I'd say what's surprising about the evidence in this case is the lack of any sort of quantitative evidence from the stakeholder groups. And we can see that if you look at all of
Sorry, when you say from the stakeholder groups,
sorry, I mean
surely short
in that because
from
they
the,
were,
but the evidence has really got to come from the claimants in this litigation.
yes.
It's not satisfactory for us to be looking at various representations made to civil servants in the course of the development of the policy, because that's just patchy and partial. And
Yes.
I mean, if they produce some statistical evidence and put that in, no doubt that could be borrowed and relied on by the claimants. But the sorts of observations made here and there by what you call the stakeholder groups aren't really evidence.
You misunderstand me. I was referring to the evidence adduced on behalf of the respondent. I called it stakeholder because it's the same charities that were involved.
Oh, I see. Okay, well,
It's my fault.
don't worry. Let's say claimant too, because respondent is confusing. Yeah.
Right. So, can I just give you some examples of this in terms of that lack of robust basis? We have a witness statement from Save the Children, and I don't ask you to turn it up because these are things I think if you look at it, you'll see the point. In terms of quantitative numbers discussed in that witness statement, Miss Lawton referred to 4 parents who gave evidence to a select committee and said that the charity had worked with 16 parents. That's at page 225. And she gives a couple of individual examples at paragraphs 23 and 24 of people who were disadvantaged by the measure. The first person she refers to is an individual whose shifts vary from week to week. So it's exactly the sort of person who this benefit assists because it helps those people who are working on a flexible basis. Paragraph 24 refers to one person who faced high charges in the summer, but that these problems were alleviated when they moved their child to a nursery that offered the free childcare offer. Now, in terms of statistics, she refers to there being 50,000 families receiving universal credit at that time, 41,000 of whom were single parents. But yet there is just not that sort of critical mass of concern that you might expect. At paragraph 27, she says she spoke to 16...
I'm sorry, I'm not finding this helpful. I think we've got to look at it.
Of course.
Sorry, I thought you said we needn't look at it. You just tell us about it.
I was, but I think you've said it's not helpful.
No. Can we look at it then? Where is it?
It is in bundle 1.
Yeah.
So, my lord,
It's a supplemental bundle. Tab 2.
supplemental bundle tab 2, page 221.
Thank you.
My lords, just for your note while we're in this, she relies on childcare costs fluctuating at paragraphs 2 and 18 of that statement. At paragraph 7, she refers to 4 parents giving evidence to the select committee. At paragraph 12, she refers to working with 16 parents. At paragraph 23, refers to one parent.
So is your point that this is all what you might call anecdotal? No doubt true for those individuals, but not capable of giving an overall picture.
Precisely, and that picture is followed through all of the evidence in my
Okay.
submission in this case. So paragraph 27, she refers to having 16 interviews with a range of childcare providers. And then at 28, we find that although the impact on child providers has been fairly limited so far, a pattern's emerging as to the problems providers face. And it's in her evidence, again, just while we're here, and this is at page 353. And this was evidence to the Select Committee at paragraph 1.3. Unlike rent or other bills, childcare costs fluctuate wildly week to week, month to month. This means that upfront costs will strike a family at multiple periods during their young child's life.
It's interesting because if one looks at paragraphs 12 onwards, one initially reads it as referring to 16 parents that they work with. But the more one reads on, not sure that it fits in with it just being 16 people. Take the point that 16 people isn't a very good statistical group, a very small statistical group. But for example, at the end of paragraph 18, most low-income parents with a child aged 2 or above find that their childcare costs increase every 6 weeks.
Well, that might be a general observation, but
Yeah.
in terms of actually looking at a statistical or a reliable basis for understanding how widespread these effects are, as opposed to giving rise to some difficulties for some people, my point simply is that the claimant's evidence didn't get there.
Okay, sorry, I made you show us that because I wasn't
Well,
able to
my
take
lord,
you did it
can
that
I-
way. Where do you want to go next?
If you want to look at it, we can go then to the gingerbread evidence.
No, sorry, we're at cross purposes. I don't want to look at anything that you don't want to tell us about. What I just didn't like was you telling us about stuff without us having the thing open in front of us. So if you want to tell us about gingerbread, we'll go to it.
Well, my lord, I'm sorry, you were anxious that I finished today and you wanted to
No,
move me on.
please.
So I'm
I'm not
to...
being critical at all. I'm just explaining why I wanted to see that. It wasn't because I wanted to see it, it's because you wanted to show it to us.
My lord, gingerbread at 366.
Yep.
Also provide a small number of examples of people who they say that they've worked with. So they refer to case studies that they have looked at. And I'll come to the interviews that they say that they conducted. But if you look at paragraph 12, so one example of someone who paid for their childcare is on a pay-as-you-go basis. And then the second example at paragraph 13, someone whose hours would change every week and who had to pay and claim for child costs on an ad hoc basis. I think that was evidence that they were relying on in front of the Select Committee. And then at page 402, this was a paper on single parents and in-work progression. They discussed interviews, so this is page 402 at the end. That paper was predicated upon interviews with 15 people. But in fact, if you look at page 425, you can see that of the people interviewed, 7 of them were recipients of universal credit.
So I'm sure you're right. Where do we see that?
So if you look at that.
Oh, I see. If we go down the right-hand column.
Yeah.
Yep,
So
okay.
a number of them.
Yep, got it. Thanks.
My Lord, the respondent also relied on evidence from nursery providers, although her child was an older child and going to an after-school club. And again, paragraph 5 at page 439. He says in terms, we don't know enough about the challenges of the childcare element of universal credit on a large scale. He's talking about 2 providers.
Save the Children have a slightly wider ambit.
Which
343. I didn't know whether you were going to take us to that, but there's a witness statement from Save the Children, which is quite detailed.
Do you know, my lady, if that mentions an evidential or the numbers of people who formed the basis of that written evidence?
Without looking at the survey which is referred to in the footnote, for example, footnote 15, or any of the other surveys on the hyperlinks, it's impossible to tell how big the surveys were and how many people were actually canvassed. But they seem to have done some fairly detailed research on the question of the impact financially on both couples and single parents.
My lady, there's obviously that in 2014 the legacy system would also have been in place. So that's why, for example, the gingerbread evidence incorporates people who are still on the old system. I entirely accept that a number of these reports speak to the high costs of childcare and of upfront payments.
This is specifically focused on universal credit. Page 348, the difficulty of upfront costs.
Yes.
4.17, there's a clear imbalance between how support is claimed under universal credit by lower income families and the tax-free childcare system, and they're doing a compare and contrast with tax-free childcare, which of course is for people on higher income.
Yes.
So there does seem to be, all I'm saying is that this particular report by Save the Children, although we don't exactly know, unless we go to the underlying statistics or the underlying surveys, how many people they canvassed, they do seem to have got a wider evidential base for what they're saying than looking at 16 people.
Yes, but it's obviously quite difficult to say without knowing, because one might expect to see some sort of indication of the kind of numbers that were involved.
But in any event, the reason why you are taking us to these reports is simply to illustrate that there isn't a kind of statistical analysis that you would say was necessary in order to make good the disproportions being required.
I take the point it mightn't be necessary, and that's why I've been careful to suggest that you need to have a robust evidential basis for being able to demonstrate a disproportionate impact. And the concern here is actually that there was a low, or there was an unclear evidential basis. And the witness statement on behalf of the minister expressly refers to the fact that there wasn't quantitative evidence of there being a large-scale problem about this. But I'll take you to that, I hope, in due course. But my lords, the same points were made as regards the nursery school evidence as well. So you have Mr. Broadbury at 438. Again, I don't know if you want to go to it, or I can give you the references.
Sorry, I won't say one more. If you want us to tell us what things say, I like to see the document. But if not, I only want to go where you want us to go.
So, my lord, Mr. Broadbury at paragraph 5. That's where he says that we don't know enough about the challenges of the childcare element.
Thank you.
Paragraph 17. He said that they hadn't been able to conduct comprehensive research in relation to the impact of universal credit. He does go on to say we collect reports from nurseries seeking support, and a dozen members have reported difficulty with parents in receipt of universal credit. My lord, there's also a witness statement from a Miss Bayram. They again are, I think she represents the she represents the interest of providers to children under the age of 8. This is at paragraph 3. Her organisation doesn't work with families, but has a small number of provider members delivering early education. My lord, she did provide a survey then in later evidence, which is at page 546. She said that they got 209 responses, of which 78 providers provided evidence about families receiving universal credit. And she gave examples from 4 of them. My lord, again, if I can just quickly take you to that survey. Page 579 of bundle 2.
Which bundle are we in, sorry?
It's bundle 2.
Yep.
So, just looking at so they're asking about the payment of upfront childcare costs. Children of families that rely
Sorry,
on...
just tell me, this is a survey by whom of what?
This is a survey by Miss Bayram's organisation.
Yeah.
So it's set out...
Yeah, don't worry, yeah. Survey by Bayram of a number, obviously of a number of child
Paragraph
numbers.
9, they received 209 responses.
Thank you.
And 120, this is at paragraph 10, have children from families who receive universal credit. And then she goes on to say at 11 that 78 of 120 settings said that they had encountered difficulties in receiving payment. And my lords, one can pick that up at page 579. I'd simply say about that having problems getting payments from parents on universal credit obviously doesn't really inform about the reasons why. So there are some references there to them saying that people couldn't afford it. Then things like 581, they're unable to pay me but want to keep their space as they're not working. So it's quite hard to use that, in my respectful submission, as a reliable basis for understanding why people might have difficulties. So, my lord, that's the point on behalf of the minister about the evidential base. The judge said that, and this was at 150, I accept that there's a lack of robust quantitative evidence as to the numbers materially affected by the proof of payment rule and as to the extent of the effects, but the claimant's evidence in this case comes from a broader range of informed sources. And my lord, our point about that is that it's not that it comes from a broader range of informed sources, nonetheless, there is that lack of robust evidential foundation for understanding the numbers of people who are affected.
So your point is the range of informed sources can't make up the lack of statistical basis?
Yes. My lords, we say, in terms of the reliance that was placed on the two other women in order to demonstrate the difficulties, we say as regards them that the first witness, and I'll just give you the reference for her evidence, it's at B2482, she's the individual whose statements I took you to. She is someone who got into a regular pattern, and what might be thought telling about her evidence is that although she's now entitled to the free childcare offer, she sets out at paragraph 25 that she's going to use that to have her daughter cared for on her day off so that she can get other things done. But my lord, we'd say about that, the fact that...
Sorry, where are we looking at?
So this is the witness whose evidence appears at B2482, bundle 2.
Bundle 2482. Yep, thank you. Which paragraph are you commenting on?
Sorry, my lord, will you give me a second? So, my lord, at paragraph 25,
Yep.
and can I also just direct you to her? So she's got entitlement to free childcare, but as that demonstrates, she's not using that to reduce her childcare bills. She's going to use it to add to her childcare. And my lord, at page 544, she sets out an example of her incomings and outgoings. But again, in my submission, that makes clear, if this is supposed to be a snapshot of how she manages, then it demonstrates that her outgoings were less.
Sorry, which paragraph is this?
So this is 544, and my lord, if one looks at the payments that she got for take-home pay and maintenance payments under universal credit, she sets out her outgoings at paragraph 2. That would tend to demonstrate that her outgoings were actually less than the amount of money that she had coming in. And just in terms of the sorts
Sorry, but so what do you get from that?
Well, my lord, that insofar as the concern is that this method of payment may cause debt or may be difficult to manage, that she's an example relied upon here who nonetheless demonstrates that she is getting the regular payment and is obviously able to manage on that it isn't causing the kind of difficulties.
Okay, but I mean, is this a useful exercise in limited time to go to all these individual cases? Your broad point, I think I have understood, which is that looking at individual cases with all their subtleties and complications doesn't help prove what the claimants have to prove, or claimant has to prove. In a sense, all you're doing is just putting icing on that cake, aren't you?
Yes, but...
if you want to, of course. I'm just worried that there's a lot of other issues in the case, and this isn't the one which takes a lot of time to develop.
All right. Well, I think you have the point, and you have the point that basing an analysis on resources available to people is obviously complicated and not a reliable basis for demonstrating indirect discrimination in the way that the judge approached this. But I'm obviously going to that evidence because it was relied on as part of the wider picture.
Yes.
And I won't take you then to the evidence of the witness SC. You have her evidence. Sorry, I may not need to get the exact tab for that. But again, she is someone who said she wasn't working because of upfront costs, but then at paragraph 29 explained that she left her job because of stress and not wanting to come into contact with the public because of COVID. So, my lord, again, it goes to the same point. My lord, I'm going to move on to objective justification, if I may then.
Yes.
My lord, the recent judgment in SC makes this easier because I don't need to go back through all of the other decisions on this. Can I just say one of the important points, though, is that what is an issue and what ought to have been the focus of the judge's consideration was the practical outcome of the process of developing the policy. In other words, the practical outcome was the way that childcare was paid. The analysis is not the reasoning which ultimately led to it. So ordinarily applying the usual Denby high school approach, the fact that a public authority hasn't taken into account a relevant consideration isn't of itself a basis for concluding the government has acted incompatibly with convention rights. My lord, this was an issue in Tagere, and I think it's worth just looking at how it was approached in Tagere. That's at tab 14 of bundle 1 of the authority. My lord, obviously this point goes to the centrality in the judgment of the suggestion that ministers weren't really thinking about payment on a liability basis.
Is paragraph 81?
It's paragraph 32 first for Baroness Hale's approach. So she's talking about the area of judgment. It's just under C, and about the respect.
So sorry, tab 14.
Yes.
Tigre.
Tigre.
And paragraph 31, did you say?
32.
Sorry?
32.
32, right, sorry.
So going to just below letter C, the respect is of course heightened where there is particular evidence that the decision maker has addressed his mind to the particular issue before us. So the usual Belfast City Council approach. Both are lacking in this case. There's no evidence that the Secretary of State addressed his mind to the educational rights of students with DLR when making these regulations, which were laid before Parliament. That's then picked up at paragraph 81 by Lord Sumption and Lord Reid, who were dissenting, but paragraph 81 is again a fairly orthodox recital of the principle. So in that case they said there's no direct evidence of the thought processes of ministers and officials as they resolved on the current criteria. And they went on to say that wasn't surprising because these regulations were so old. But they went on to say, nor is such evidence necessary. In the first place, a challenge to the decision under the conventions, not a judicial review of the decision-making process. And then citing Bingham, what matters in any case is the practical outcome, not the quality of the decision-making process that led to it. And then going on to say that the objectives were in any event clear from the regulations themselves. Now, the same point was picked up in RJM at tab 8. I don't think we need to go to it. For your note, it's Lord Newburger at paragraph 52. The question is whether the policy can be justified when it's attacked. The same approach was applied in the Joint Council of Welfare of Immigrants case. And again, for your note, at tab 29, paragraph 147, the complaint was that Parliament enacted the provisions unaware of the discrimination that would result, and the court said that it wouldn't speculate about what the expectation of Parliament was about that. And my lord, when we come to the C case as well in the Supreme Court, one also sees that difference as well, or that area of judgment being afforded, that the court is restrained when it comes to looking at the reasoning process. My lord, it also links to post hoc reasoning. We say there is no post hoc reasoning in this case. It is abundantly clear from the outset that ministers were concerned to arrive at a scheme based on a reimbursement model that best addressed the concerns about fraud and error, and also obviously that the issue was raised about upfront payments. But even where post hoc reasoning is engaged, per Brewster, and I don't ask you to go to it, retrospective judgments made within the expertise of a decision maker are worthy of respect, provided that they're made bona fides. So, my lord, taking that into account then, and looking at the SC case, which is in bundle 2, at tab 31.
31.
Well, perhaps the most important paragraph is 158 in this context. A low intensity of review is generally appropriate in cases concerned with the judgment of social and economic policy in the field of welfare benefits and pensions, so that the judgment will generally be respected unless it's manifestly without reasonable foundation. And then at paragraph 161...
Hang on one that rings a bell, but which bit of 158 is the long paragraph? Which particular bit were you relying on?
Sorry, so it's paragraph 158.
Sorry?
Paragraph 158.
In SC?
Yes.
It's line 3 onwards.
Line 3, thank you. Yes, I mean, that's, as you say, that's important. But really the rest of what he says is qualifying that.
Yes, I accept that, and I'm going to come back to those factors. And then at 161, that it may be more fruitful to focus on whether a wide margin or judgment is appropriate in the light of the circumstances of the case. So the first few lines of that.
Yeah.
And again, reiterating at the end of that paragraph that the ordinary approach will accord the same margin as the manifestly without reasonable foundation test, where a particularly wide margin is appropriate. And at paragraph 162, pointed to the increase in challenges based on Article 15 in the sphere of welfare benefits, setting out that they've become increasingly common. The favoured ground of challenge is usually Article 14 because it's easy to establish a differential treatment of some category of persons, especially if the concept of indirect discrimination is given a wide scope. and then pointing out to the risks because of the breadth of proportionality. That there's a risk of undue interference by the courts in the sphere of political choices. And that risk can only be met if the proper boundaries are applied. Again, he reiterated that at paragraph 171. That decision makers aren't expected to comply with the judicial standard of rationality. My Lord, my Lady, much of the paragraphs that follow is also concerned with the reliance that can be placed on parliamentary materials.
Yeah, well, in fact, that's it. Although relevant, what you've read us from 171 is part of the bit about use of parliamentary materials, which starts at 163.
So again, citing at 1763, yes, the Denby Schools principle. And then again, he makes the same point at 182.
Sorry, are we at cross purposes here? If this is about, there's no issue about parliamentary materials.
No, there's not, but in my submission I say principles apply when it comes to look at the reasoning process that was adopted by ministers. So the point that's being made at 1763, that's a Denby Schools point, that applies.
Yes, I see, yes, but you, as you say, you've referred us to all the learning about that.
Yes, but I think it's really important that SC is a reiteration of that.
Okay.
And again, at paragraph 182.
182 reflects the point that you made in this context, but it does so in the parliamentary context, which is you don't look to see whether the minister actively turned his or her mind to the particular issue as to whether it was going to disproportionately affect women, except in the context, presumably, in an equality assessment. But if you've not got a challenge under the Equality Act, then you don't need to go there. You just... If there's some positive evidence that the minister did consider it, then that, if you like, makes it even more difficult to challenge.
Yes.
But the absence of it doesn't make it easier.
Yes. Precisely so, and that's why the court here was obviously concerned about parliamentary debate, but again picks that up. The court must not treat the absence or poverty of debate in Parliament as a reason for supporting a finding of incompatibility.
So where was that particular phrase?
That's at 184.
Yeah.
And then just going on to 192, the court found that focusing on the objective of protecting the economic well-being of the country is undoubtedly a legitimate aim. I'll come back to the justifications. What I just wanted to pick up on at this point was that one of the issues then was whether or not the intensity of the review was lower whenever the difference in treatment was based on one of the suspect grounds of gender. And as I've said, that goes then to the issue of how suspect grounds and weighty reasons applies in the context of indirect discrimination.
And are you about to show us where he deals with that?
He does deal with that in sorry, I have lost the...
Don't worry, take your time. I mean, what I was wondering, and I have obviously looked at this, but I haven't analysed it carefully in advance of your submissions, is whether he says anything along the lines of, in an indirect discrimination case, the especially high test of justification required for a suspect ground is less high.
So he does take into account.
Where does
If we can say it at 112.
112?
Sorry, I'm.
189.
Sorry. Thank you very much. 189.
Thank you. Yes, thank you. I hadn't focused on that, but
It starts at the second half of 188, in fact.
Yes.
isn't it? So it's endorsing the European approach.
So he's really saying, yes, that Detrizio appears to have the same high burden, whether it's direct or indirect. He is sympathetic with the contrary view expressed in the United States, but loyally follows is the wrong word since it's Strasbourg, but is prepared to accept the Strasbourg approach. So is that what we should do?
So, my lord, but what he ultimately, in the overall effect of SC, is to say that whether or not you apply the manifestly without reasonable foundation test is contingent on all of the circumstances of the case, and that there isn't a hard and fast rule where discrimination is based on weighty reasons. So he's counselling against any sort of approach that treats it as a binary question.
Yes, that's
Or
helpful.
which
Which paragraph
says that
are you
if it's-
relying on in particular? Are you summarising there?
Sorry, my lord, will you forgive me? I have
Yes.
lost my note on
Don't
it.
worry at all. It happens.
I'll ask
happens
my
the best.
junior to just
Yeah,
give me
don't
the best.
spend time. Yes, I mean I have obviously I looked in particular at some paras 157 to 162, and to some extent.
Yes. So all of his, so that there are a number of paragraphs on it. Obviously, it starts from paragraph 100.
Well, all I really wanted, you were saying that the bottom line on manifestly without reasonable foundation is that there's no one-size-fits-all approach. There's no binary approach. I just was wondering what paragraph in particular you were seeking to paraphrase when you said that. Really, I suppose, is it the second half
So
of 158?
It's 157, 158, and 159. I'm grateful to my learned friend. I'd lost my note on it.
Don't worry at all.
And indeed, 161, it's really the whole of that passage.
Yes.
isn't it?
Yeah.
Sorry,
Thank you.
That's
Yes.
where I lost my place. I had already taken you to that without stopping.
Yeah, don't worry
To
at all.
say that was the mechanic, that was the
Yeah.
underlying reasoning for paragraph 161. So just in this issue about where suspect grounds then fits in with all of that, obviously one sees from cases like Detrizio that was discrimination based on the fact that the benefit wasn't given to people who worked part-time. And you see in the court's reasoning that I took you to that idea that there could be any discrimination that was based on perpetuating stereotypical notions or the bit about men's primordial role in society, that those were the kinds of suspect basis or the foundation for a suspect basis, in my respectful submission, that was really what the European court was getting at on a more precise analysis. And my lord, we know that that's an issue that has already come up in domestic cases, so it came up in the MA case, which you have in Luce. paragraph 61. I think this is probably familiar.
You say we got it loose. You say MA. Did you mean AM?
Sorry, AM. rather
Yep.
than MA. So in that case, the Court of Appeal rejected that weighty reasons actually had any role to play in indirect discrimination at all, for the reasons that are set out at paragraph 61.
Is this Lord Justice Maurice Carroll or Justice Elias?
It's Lord Justice Elias.
Thank you. Yes.
So I would of course accept that SC is going beyond that, but nonetheless, in my respectful submission, it still requires interrogation of the precise reasons for the discriminatory treatment. And what we say here is that same process of reasoning can't apply to this sort of case, which is utterly removed from the detritio or hugendic case, which were based or which were indirectly discriminatory on the basis of those stereotypical or outdated notions that worked against women. And we say that in the context of this case and on the facts, given that the benefit was designed for opposite effect, that it wouldn't be appropriate to apply that same sort of approach or that same sort of sanction. And it's clear that SC recognises, even if this were to be described as discrimination on a suspect basis, that you have to take into account all of the context. And that context must include, in this case, the fact that this was a benefit that was going to be afforded with a good deal of flexibility, that it was going to be paid at an increased rate, that there were going to be far more people taking it up on a flexible basis, that one must factor in to the consideration all of those points, obviously when it comes to justification and the context or the application of the weighty reasons test. The submission is that in the context of this case, it doesn't require a weighty reasons analysis. Well, look, the precise basis upon which the court decided that there wasn't, or that the case was not made out in SC is set out. And I rely in particular on paragraphs 195 onwards. The court there proceeded on the basis that it was inevitable that women would be disproportionately affected by legislation making changes to child-related benefits. That at 198, the differential impact wasn't a special feature of the measure. It would be inherent in any general measure which limited expenditure on child-related benefits. And then at 199, when it was understood that the legitimate aims could not be achieved without a disproportionate impact on women arising from the demographic factors, the only remaining question which can be asked in relation to proportionality is whether the inevitable impact on women outweighed the importance of achieving the aims pursued by Parliament.
Not quite this case, though, is it? You don't go so far as to say that the legitimate aims couldn't be achieved without a disproportionate impact on women.
No, that's correct. But in my submission, this case follows the same sort of line of reasoning. Of course, in the case in SC, the result was that the women in this position were completely cut off from receiving the benefit. We obviously say again, that's a critical point of distinction between this case as well, given that it is based on a reimbursement model. It can't be compared to the benefit cap cases of the cases where the benefit was being removed.
Well, what's being said is that they can't take advantage of the benefit which it was intended that they should take advantage of because of the requirement to pay up front, which disproportionately more women are unable to afford. That's the argument.
Yes. Well, I don't think there's any point in me going back over the problems of an argument that's just based on the resources available to individuals, because as a matter of law.
But as I understood it, your point is that it's objectively justified because even if it does have a disproportionate effect, which you don't accept, but even were that to be the case, there are wider socio-economic aims to be achieved, including trying to put people back into work and to create as close a model, the point you made before lunch, as close a model as possible to the model where you've got people who can afford to pay for childcare. And also the point about dissuading fraud and getting more accurate means of payment without errors being made. And so you've got to take all of that in the basket, and if you stand back and look at that, you can't say, whichever test you apply, that it's outside the wide ambit of appreciation given to the minister, or it's manifestly without reasonable foundation, or even that there aren't very weighty reasons if you have to apply.
Precisely, and even if you were, even if you were to apply a weighty reasons test, our submission would be, well, there were weighty reasons for wanting to opt for this model in order to reconcile all of the different policy aims that had to be met, and in particular designing a system that was simple and which operated against fraud and error in the most effective way that was possible, and which also recognised that there would be flexible ways of working as well.
Whereabouts, if at all, does the argument that it would have been possible to achieve all those aims by payment on an invoice basis rather than on a receipt basis, where does that argument come into it then? Are you saying that's an irrelevant point because the fact that you could adopt a different measure which might have had a slightly better effect is just not a viable argument to go down? Or do you say that it is a viable argument but it's not actually shown on the facts?
Well, it's 2 points. None of the cases permit an approach based on you didn't take this into account.
No.
First of all,
Understand
so it's
that.
not you can't have a defect in reasoning.
No.
I think some of the cases might suggest, well, you could have exempted this group of people. You know, there's a simple, the thalamus type of discrimination.
But this isn't thalamus.
This isn't a thalamus kind of case, so it doesn't fall into that bracket. But none of the cases permit an approach of saying, well, there were different policy alternatives, and you could have. It's possible that you could have opted for this one.
Well, I think that what I'm trying to explore with you is to how far that goes. I mean, I take the point that you can't say you didn't take into account the possibility of doing it in a different way. Get that point entirely.
Yes.
And I also get the point that it's not good enough to turn around to show that something's discriminatory, to say, well, you could have done it better by doing it in a different way.
Yes.
But if it could, just for the sake of argument, if it could be shown that the discrimination could either be eliminated or substantially ameliorated by taking a different route. Is that or is that not a legitimate point? Because that seems to me to be at the heart of the judge's justification for this. And that's why I'm drilling down into it, because I think this is what the key point is in the case.
My lady, that's so that the judge didn't ultimately find here's a clear-cut alternative you could have taken, which would have ruled this out.
Well, I know he
because
dodged it slightly.
He appreciated that the whole system of universal credit is predicated on payment in arrears. And so that's why, and I was going to come to it, but there's that part of his judgment where he says, well, I appreciate that there are other factors. For example, would childcare providers be willing to wait to be paid? So he wasn't even positing it as a clear alternative. He recognised that there were other factors that you would have to then consider as to whether or not that would actually make any difference. And that's why, in my respectful submission, there is an important constitutional issue here, because the election was made that childcare costs should be paid within universal credit at the end of the day, and there were important policy reasons for that. And a system, and it, I think on analysis, what's actually being contended for here is a system that allows your childcare costs to be paid for before you have to pay them. I mean, that's ultimately the solution, but that's not a solution that lies within universal credit. That would be outside universal credit, because it would be contrary to the whole idea that you're paid in arrears in the same way.
Well, I thought you accepted my Lord Justice Warby's point that he would be paid in arrears, even if it were paid on an invoice system.
That's what I'm saying.
Well, then why isn't...
That's what I mean, it's the practical difference. If you were paid on an invoice and you still had to wait for the end of your assessment period and then wait for there's still a delay. And that's why the judge was saying...
That is potentially a point against you. Your objection, as I understand it, is it would be against the policy and it would drive the coaches and horses through the overall policy that you only pay in arrears to pay on the invoice. It's been pointed out that even if you pay on the invoice, there will be an element of arrears. However, there may be a means of eliminating what is said to be, without deciding it, a discriminatory measure, because that is going to have a beneficial effect on the disproportionate number of women who can't afford to pay in advance. That's the argument, whether it's a good one or a bad one. At the moment, I'm struggling to understand why the policy to pay in arrears is an answer to it, because you're paying in arrears still.
And maybe I apologise if I'm at cross purposes with you. That's the point about the judgment. That the judge found that whether or not paying on a liability basis would make a difference would depend on whether childcare providers would wait to be paid. So you raise your invoice and say, this is what I'm going to pay to the Department of Work and Pensions. Your childminder still, if they want to be paid up front, they're still going to have to wait for the end of the assessment period. And
it's not going to have a practical impact.
Exactly. So that's what I mean about the constitutional issue that this raises. It's, do you ultimately, is what's wanted a system that isn't within universal credit, and that's what ministers decided.
But I haven't quite understood this. Isn't this the judge's point? I may well have not got it right, but even granted that some providers won't be prepared to wait between invoice and payment, it's reasonable to assume that some will. And to the extent that some will, you will reduce the impact of the proof of payment, or you'll reduce the impact of the need to to pay before you get the universal credit payment. Even if only half of providers are prepared to wait until, in an interval between invoice and at most 5 weeks, at least 1 week, that makes a major contribution to the problem, in principle. And why isn't that something you should do, unless there's any good objection to it? Because it will reduce the disproportionate impact on women.
Can I, my Lord, I'd invite you to consider the evidence from the nursery providers in due course, because it's being provided to make the point that nursery providers don't want to wait. And in fact, one of them, I think, I can't remember if it's Miss Byram, I might get my junior to check, says that they advise people not to take universal credit people because of the delay. So persons using universal credit because of the delay. So
hang on, does that make sense? How can there be a delay if it's a proof of payment?
They're saying that the effect of the nursery evidence, I'm just trying to sum it up, and the reason why it's relied on here is to say that nursery school providers want to have the payments in advance. They don't want to have to wait for people to be paid it. And in fact,
I see. They want to have it paid in advance, not just on the day.
Well, they don't advocate for payment on a liability basis. I mean, that's one of the features of the evidence in this case. The nursery school providers want it to be paid directly to them, so that they don't have a problem with people not paying it.
But that's usual bad debt problems. That's not.
But that's one of the principal grounds that the nursery school providers press here, that they don't want to have people, they don't want bad debt. I mean, this idea that the solution to this is all on a liability basis isn't in fact the solutions that are offered by the nursery school providers, and it's not even the solution that seems to be pressed by the charities that are involved in this. I was going to come back and address you on how that part of the case developed in this claim, but I don't accept that it's necessarily straightforward. But it goes to a more fundamental point. In my submission, the court shouldn't be coming to a conclusion about objective justification on the basis of what a sector may or may not do, because you don't know. And that's where I come back to the point. The people who were formulating this policy across government, from the Treasury, Education and the Department of Work and Pensions, are all people who understand and know how the system operates.
See, looking at it a very simplistic way, I can well understand if the Secretary of State's point is we want to make sure that the money is actually used for the purpose for which it is intended. That's a perfectly legitimate policy objective. And the only way to ensure that it is used for the purpose for which it's objected is to pay it in arrears, because then you know it's been paid for childcare and there will be proof of that. That eliminates any temptation that if it's paid up front, that it might be used for some other purpose. Very simple, very straightforward. Might be a good justification, I don't know. That's a very different point from saying, well, it's got to be paid in arrears because that's going to eliminate the possibility of fraud, or it's going to, it would drive a coach and horses through the universal credit system to pay it on receipt.
But I think each of those different considerations are in play.
Well, I'm not sure they are, because I can't see how the other two fit in.
Forgive me, which two?
I can't see how it's going to eliminate fraud at all.
To base it on, if you were allowed people to pay on an invoice basis. Well, I think, I mean, again, if we come back to the point, and I'm going to put aside the point that these were subject matter experts within government who were working all of this out. But if you have a system whereby people may be having different amounts of childcare every week, where you might be paying it to someone without ever knowing if it's ultimately applied for that purpose, in my respectful submission, that is a very simple way of ensuring that it is not being used in a way that it shouldn't be, and paying on the basis that you've got proof that it has been paid. Obviously,
you've still got that problem, because if they have to pay it up front and then little Jimmy gets the measles, you've got to rely upon them to tell you that he didn't actually go to play school.
Yes, but that's, of course children get sick from time to time, but that is not, the system has to find a way of operating for the generality of people and for many different types of arrangements and different types of payment. And the fact that there might, people might defraud you by saying their child is sick, that doesn't
No, that wasn't what I was suggesting. What I was suggesting is that they might not tell you that he didn't go to play school. So they have actually paid. They've paid the money, and it's unrefundable because you have to pay come what may, whether Jimmy is ill or not, because the space has been reserved for him. But under this system, it has to be paid back. And if they're economical with the truth and don't tell you that Jimmy was sick, you're going to be none the wiser.
Yes, but my submission is that the fact that there might be possibilities for fraud around the proof of payment rule can't be determinative about the fact that the proof of payment rule is generally a reliable means of...
And there's this, you could say it's as easy to fraud, with real outright fraud, it's as easy to forge a receipt as an invoice. But there's this difference that with a receipt, you can say, thank you, can now please send the bank statement showing this payment was actually made. Whereas that checking mechanism is not so straightforward with an invoice.
Yeah, but there's the point, a childminder in good faith can give you an invoice. Getting a receipt is obviously saying something has been paid when it hasn't is something quite different as well.
The premise of something my lady put to you earlier was one of the things I think we left over lunch and didn't come back on. I think we're proceeding on the basis that the rules provide that in the situation where you pay up front for childcare and then don't take it up for sorry, let's absolutely spell it out. You pay up front for childcare. You are paid for that payment in the next month, 7 days after the assessment period in which you paid it. Then, when later in that assessment period, or maybe even in a further one, you don't actually take it up, you have to repay it. You were going to show us that is actually what the rules do provide for.
Rule 34A provides that the childcare must...
Perhaps just while you're looking at that, I just put this thought into your mind. I'm not. When I was thinking about this beforehand, was really thinking there are only two scenarios. You pay on the day. You take the child away from the nursery and hand over a check or an envelope or show your card to the reader, or you pay later. I hadn't really focused on the fact that many nurseries may require you to pay upfront, maybe weeks upfront, may pay a whole term in advance. I don't know. Is there any evidence about that? About the split between upfront payment on the day and payment afterwards?
I don't think that there's a clear forensic...
All you can say is that all three are possibles.
Yes, so I think that there is some evidence that's, I think it's in the gingerbread evidence, that around 60% of nurseries, I think it is, I can't remember if it's, I can check childcare in general, operates on a monthly basis. And I think that
what does monthly mean? You mean monthly in advance?
Monthly in well, no, it doesn't. it may be better if we look at it carefully to be sure.
Well, I don't want to waste time. If you haven't got it at your fingertips, you can let us know, or Mr. Butler may know, may tell us.
And I think that it may be that of those, most expect an upfront payment, but how that applies.
Well, either there is evidence or there isn't. But I mean, I think also, I've got no feel at the moment. What I've picked up from the evidence I've seen is there are nurseries, there are after-school arrangements for which you have to pay,
Yes.
and there are childminders who will be much more informal, though they will still have to be registered. And they all probably have rather different characteristics.
Yes.
I think whatever the answer to my Lord's question may be, I haven't found any reference to an answer to it in the judgment. Am I right about that?
I think that the judge said in terms that there wasn't any clear.
And he's got a list of things that you can draw from the evidence
Yes.
in his paragraph 151.
Yeah.
And I've gone through it a number of times while the argument's been proceeding. Possibly a reason why I missed out what you said about the passage that I've highlighted. But anyway, I don't think it includes anything anything about the relative propensity of childcare providers to require payment at any particular time, before, during, immediately after, or sometime after.
I don't want to mislead you
No.
because I thought he had somewhere, but let me.
He said, well, it's E, paragraph E. There's no quantitative data showing the proportion of childcare providers which require payment and or deposits up front. There is, however, good qualitative evidence showing a significant proportion do.
Yes, and that might be a
That's the
reference to
passage.
the gingerbread
Yeah.
evidence.
And then he refers to Mr. Broadbury's statement and Pacey, which you took us to.
Yes. So, my lords, the point that I think arises is in terms of I think it's the point at regulation 34. The amount of the childcare costs element for an assessment period is the lesser of 85% of the charges paid for relevant childcare that are attributable to that assessment period.
It's the
Yes, but that-
definition.
Then at 34A as well.
But hang on, the charges paid for relevant childcare would include, in principle, payment in advance, and indeed
Yes.
34A.
Yes.
So I haven't quite got where it comes from that if you pay perfectly bona fide and genuinely for it in advance, and the money's left your hands, and you have claimed for it, and then you don't take it up, you have to pay it back again.
It's 35(2).
Is it?
Care
Grateful.
provided.
It's the definition of relevant childcare as care provided for a child by a person registered, which seems to me to suggest that the care has to be provided.
Maybe. But you expect if there is an obligation to repay that there had to be a mechanism for it, wouldn't there? Isn't
Sorry, my lord, I didn't.
if there did have to be an obligation to repay. I'm sorry, I don't want to. Can we just?
No,
Can we just
sorry.
quickly try and bottom this out? One, are you confident that in the situation I posited to you, let's say the nursery demands payment up front for, let us say, a 3-month period, to make it easy, and you pay it in the first month, that you will be repaid that? You will be paid that on day 7 of month 2,
Yes.
or is that how the formula perhaps
The
deals
childcare
with
has
it?
to have been received, so it has to have been provided in the assessment period.
Yes, I see.
Or,
Or
as I
within
understand
3
the
months.
operation of the regulations, there's leeway in that it can also be provided in a following month, so you get the
Probably,
chance
if I read this carefully enough, I'll see all that. But if your junior wouldn't mind just doing a very simple, hopefully sees what's worrying me, and there is an easy answer, I'm sure. But if you just do a step-by-step answer overnight, and then it'll become clear. I won't waste anyone's time.
I must admit that I haven't, in a quick trawl through the regulations, found a specific provision that says that if you pay up front for the childcare and it isn't provided, you've got to pay it back. I haven't found anything as clear as that, but if it exists, no doubt your junior will be able to find it for us. The nearest I could get was an implication from the fact that the definition of relevant childcare is of care provided for a child.
I'm sure the system does cater for this in some way. Maybe they take it on the chin. Genuinely paid, and then little Jimmy gets the measles. The government takes it on the chin just as the parent would if they were paying. But who knows?
Yes. Well, we'll make sure that you have the answer to that.
Thank you.
Tomorrow. My lord, I'm just really conscious of the time.
Yes, of course. Well, if you really can't finish, despite what we said, if you can't finish today, and we'll obviously eat into tomorrow, but not, I hope, by very much. No. And then if Mr. Butler can't finish, we'll have to go into the third day. But let's see.
Yes. The two other points are obviously quite short. And Johnson, a lot of the foundation from Johnson, for the Johnson argument, has obviously been laid already. So that will just be a pure... so again, I just wanted to return then, if I can, to the judgment. So the High Court said at paragraph 172, in terms that although it was going to apply a manifestly without reasonable foundation test, it wasn't appropriate in this case to apply a wide area of discretion. And the first reason was set out at 169, because he said weighty reasons were required, because this was discrimination on a suspect ground. And my lords, I've already set out why we say that he was wrong to approach it on that basis. And then the second reason why were all of the points that he set out about the consideration that had been given by the minister to this issue, or the lack of consideration. And that's set out at paragraph 170. It's really from D onwards.
Yep.
And he set out, so if we look at, so A to C, aren't really what's an issue. So at D, he seems to have found that the discretion could be reduced, because although ministers, the briefing made clear and ministers understood well that childcare costs would be paid out, would be based on what was paid out. This showed, the judge went on to say, that someone had formulated the proof of payment rule, at least as part of the proposal. But there was nothing to indicate that the minister's attention had been drawn to the difference between the system. Oh, my lord, we say that that's just going too far. But moreover, of course, ministers would have understood the difference between having a system based on actual costs as opposed to a system that was based on an invoice. He goes on at E to say that he accepts that at the briefing the issue was addressed, why doing cash rather than invoices, as the summary was put. And the court went on to state there that the response was given by officials. So he seemed to make something of the fact that officials were aware of this. But again, in my respectful submission, this just isn't really realistic. It's obvious that all of these matters were under discussion. The point is whether officials or ministers considered this. The point was obviously a sound one, that if you were going to pay out on the basis of a liability, there would be bound to be some sort of invoicing. And the real issue is that consideration was obviously given to that. My Lord, at F, I think that this goes to the same point, that the note properly flagged up, this is the note to the Minister, concerns about the proof of payment rule, but didn't advance reasons for preferring it over a system which paid child costs when incurred. But again, my Lords, our point is that the reasons would have been obvious in the context of what was being discussed. Reasons had been put forward as to why invoicing wouldn't have worked in terms of what was to be achieved or what was being aimed at. And we say that this sort of analysis based on what was or wasn't put to ministers is not what's permitted on the case law on indirect discrimination. He goes on to say there's no evidence to show what this consideration yielded or what views minister took about the adequacy of the other support. So that's a reference to the flexible support fund. But my Lord, we say as regards that, and it's set out in Miss Parker's evidence, that the flexible support fund was then used in order to assist with making upfront payments. So in terms of the forensic point, what was suggested to ministers about the solution was in fact what eventuated. And it's quite right, and he fairly reflects that we didn't rely on that fund in order to meet the manifestly without foundation rule. But my Lord, I'm relying on it to meet the forensic point. That what was advised about it was that that would be the way of meeting an issue about upfront costs. My Lord, at H, he says that there's no evidence explaining what consideration, if any, was given when the proof of payment rule was amended. But my Lord, he then goes on and he accepts that the proof of payment rule was already set out in the original regulations. He said that there was nothing in the evidence to indicate that the proof of payment rule had been considered now. But my Lord, again, coming back to Miss Parker's evidence, she expressly said that the minister continued to give consideration to the alternatives. And despite the fact there was an absence of quantitative evidence to suggest that it was problematic, that ministers had not come to a system that would work better, and I will go to that in due course. And then the third factor, the judge said that impacted upon the area of discretion to be afforded was that the measure was contained in the regulations, and that's where he says three lines down, the universal credit regulations contained a version of the proof of payment rule, which included the key feature under challenge. Now, of course, the importance of that is that they were subject to the affirmative process, and the court in SG, which is at tab 13, applied the approach in that case to that which had been taken in Bank Mellet. When a statutory instrument has been reviewed by Parliament, respect for Parliament's constitutional function calls for considerable caution before the courts will hold it unlawful on some ground, which is within the ambit of Parliament's review. So it's clear that...
What paragraph in SG is that?
That is, I think it's paragraph 94. Yes.
Thank you.
And my Lord, it appears at the end of that paragraph, as the judge says, the fact that the proof of payment rule was included in an instrument approved by most houses means that a greater area of discretionary judgment is appropriate. But it's obviously clear that considerable respect has to be paid when it's contained in that sort of measure.
It doesn't say he's misdirected himself here, does it?
Well, I'm not sure that it reflects necessarily the force of what was said in SG. I mean, he just says it's a greater area of judgment. That's not saying I should apply considerable caution. before deciding on proportionality. So my lords, he then drew everything together at paragraph 172, and again he goes back to the point there's no evidence that the decision to make CCE dependent on proof of payment, rather than that the proof of charges have been incurred, was ever directly considered by ministers. And again, my lord, we say that that just goes too far. That is going to a defect of reasoning. That is not going to whether or not the measure ultimately selected was objectively justified.
Couldn't it simply be going to the fact that you don't have that extra layer of insulation that you would get if it had been directly considered?
Well, my lady,
what the law, the various cases that say, well, if it was directly considered, then it's stronger still in the less you should interfere with it.
well, and that if it's not there, that's just exactly something that you can't take into account. But
Bit of a logical oddity there. You can say that its presence gives the decision maker an extra protection, but its absence doesn't detract from his protection. Quite.
well, I think that when it's a baseline, isn't it? What Baroness Hale was saying was when it's present, that's obviously an extra or an element that
Is either capable of making a difference or it isn't.
Yes. But Milo, coming back to the facts of this case, of course, the minister was aware, and it had been drawn to his attention that concerns had been raised about upfront payments. And the solution offered was that there should, that payment, there should be recourse to the discretionary fund in order to meet that. And as I've already said, on the evidence before you of the three women who've been relied upon by the claimant, one of those did indeed have recourse to the flexible support fund to have all of their first month's childcare met.
There was this bill was a responsibility. There was a Minister for Welfare Reform, wasn't there?
Yes, it was Lord Freud at the time. Right. Yes, but you can see from the submission materials that there were three ministers, I think, who all had involvement in this area.
Yes, but the primary ministerial responsibility under the Secretary of State was Lord Freud.
And my lord, what we would say overall about this is that it's clear from this judgment how much the judge made of the fact that there could be this liability basis and compared it to housing. And obviously what we say about that, and you saw from the Act when we originally looked at it, housing was provided for under the 2012 Act, which specified that it could be paid on a liability. Now, aside the fact that under universal credit you're still going to get that payment in arrears, we also submit that there are clear and obvious differences in any event about housing and the way that it's paid. And first of all, of course, that housing costs are by and large fixed. They don't tend to fluctuate in the same way that working hours might fluctuate and childcare fluctuates. The terms of housing obviously crystallise in a tenancy agreement if an accommodation is rented. Housing goes to the most fundamental of needs, and obviously depriving someone of their housing is attended by lots of procedural safeguards as well. So, my lord, the additional point to all of this, and it may also come into the point about comparison between individuals entitled to housing, so in other words, the comparative point as well, that there is no comparison between a system for paying housing costs, to which the claimant here was entitled, and the system for paying housing. They're both aimed at meeting very different outcomes and needs. And the judge then set out at paragraph 173 onwards a number of other points, which he said favoured the conclusion that there wasn't objective justification. The first one was what was said by Miss Parker, that the key feature of the childcare payment system, and in other words, that it was based on actual costs, ensured its accuracy and addressed the problems of fraud and error. And then he went on to say that none of the alternative mechanisms proposed were proposing a system of estimated costs. But again, my lord, my lady, for obvious reasons, we say that that wasn't the point. Of course, there was a move away from estimated costs, but the additional policy imperative here was to find a way of paying for childcare in a way that minimised fraud and error. My lord, at B, he said of the evidence that taking childcare outside universal credit would require an enormous amount of investment and resource, and he dismissed that on the basis that it was not particularised, applying the principles in Brewster and Langford. And my lords, we say about that, Brewster and Langford were completely different cases. Brewster was concerned with filling in a form that was regarded as superfluous, and Langford was about individuals being married to someone when they were with someone else. My lord, we say that it goes too far to simply dismiss the Secretary of State's concern on that basis. Taking childcare out of universal credit or trying to reconfigure the system to be based on liability to take into account all of the additional work and calculations that would have to be done would obviously be considerable and would also be contrary to the aim of simplifying the system as well. So he said that that was a reasonable foundation, that childcare costs should not be met by direct payment. But then he goes on to say, but direct payments to providers and vouchers were not the only possible alternative. So he goes back again to this idea of payment on a liability, and he says the key focus of the argument in this proceedings has been on the difference of proof of payment and proof of liability to pay on the other. Now, my lord, I wonder if I could just take you to how the case was pleaded, and you should have that in the same bundle.
Yes, sorry, for some reason I've lost. Where's the bit? Okay, so I've got the passage. Yep.
So if you look at tab 10, the statement of facts and grounds relied upon. So my lord, one sees at paragraph 30, the case was brought on the basis of indirect discrimination. Differential effect was set out at paragraph 40.
So sorry, which page are we on?
I apologise, it's tab 10, page 153. The grounds of challenge, so set out at 162.
Yeah.
Differential effect was set out at paragraph 40. And then the reasons why it was said to be manifestly disproportionate was set out at paragraph 44, page 166. And then at 5th, the pleadings set out the obvious ways of promoting the operational aim. So it was based on a childcare deposit guarantee direct payments being made to childcare providers, the creation of childcare accounts, affording decision makers a discretion to allow upfront payments on a case-by-case basis. So, my lord, just again coming back to that point, we would return to the reality of what was being discussed as between ministers and officials at the time this policy was being worked out, that they wanted to implement a scheme being based on actual costs. They had a sound reason for not wanting to implement a scheme on the basis of invoices. They knew that there were concerns about upfront payments, and there was a policy solution as regards that. My respectful submission, that was sufficient, and that the court wasn't warranted here in going beyond that, taking into account different policy outcomes that may or may not have.
No, well, I see that entirely, and I hadn't looked at the pleading, but I dropped the hint that the case had morphed a bit. I'm not clear what stage it morphed, though. Was there ever any formal amendment of Para 49?
My lord, I think that in my learned friend's skeleton argument for the hearing, that's when the comparison between housing was articulated as a legal basis. I'm sure he'll tell you. If
okay, well, we'll hear from him. We'll hear from him tomorrow. Yep. Now I see the time. As I say, I've got to rise promptly at 4:15. You haven't obviously quite come to the end. You may have come.
Finished.
Okay, well that's very good.
Oh, do you want me to keep?
No,
Sorry,
I wasn't sure what you meant by nearly finished. If you meant literally 2 minutes.
No, my lord, because I have to deal with.
Well, that's what I thought. Yes,
Johnson.
no, that's quite understood. Don't worry at all. You've been asked a lot of questions, and normally we would have sat on to 4:30 to let you finish, but as I say, we can't. Mr. Butler, if we start at 10:30 and Miss Dobbin is on a quarter of an hour or so max.
Yes.
Given the amount of ground's already been covered, I'm guessing you're probably going to be comfortable finishing the day, or would there be some advantage in us sitting at 10:15?
If I can start at 11:15 with my submissions, I can finish leaving at least half an hour for Ms. Dobbin's reply.
Well, let's do that. We have always got Thursday, but I think it for all the obvious reasons, including costs, it'd be good to get it done tomorrow if we can. Right. Then in that case, 10:30.